I am a PhD researcher at the University of Rennes in France in the domain of public law, and my research paper is called the Digital Administrative Act, and I am happy to share it with you at this doctoral consortium. So the present PhD thesis in its second year of research. The work is currently in the beginning of the writing phase, so that some preliminary ideas and conclusions may change later on. As the main goal of research, I intend to find out how the implementation of artificial intelligence and other algorithmic systems in administrative decision-making can be adapted to the civil law systems theory of unilateral administrative act and to the European legislation while respecting the rights of administrative citizens. The study is predominantly of a legal nature. The application of AI in administrative procedure is examined from the perspective of law and legal theory. In order to achieve this objective, the author uses a number of legal research methodologies. So a short sketch of applied research methodology. The thesis is based on the doctrine of French administrative law. The starting point are French public administrative legislation and the French theory of administrative unilateral act. The next step is the emerging theory of the Digital Administrative Act in French and foreign doctrine. Comparative legal approach involves studying the legislation and jurisprudence of foreign countries, mainly from the civil law system, in the field of regulation of an administrative act involving AI. The most significant here is the German legislation and Italian jurisprudence. From the point of view of empirical approach, the most promising practices for introducing AI technologies into administrative procedures are investigated to better understand their operability in the public domain, as well as their compatibility with legal theory requirements. From the point of view of analytical approach, the basic methods of legal reasoning are analyzed, the deductive inference on the basis of which rule-based systems works, as well as the inductive inference used by machine learning systems. The thematic outline of the PhD thesis and the main issues it explores are determined by the classical definition of an administrative act in French law, which can be reduced to a legal act which emanates from administrative authority and has the value of enforceable decision. In other words, it is the result of an intentional application of a legal syllogism to resolve a specific legal issue. Its peculiarity is the authoritative nature of the decision taken by the competent administrative authority, which is binding on citizens regardless of their consent. In addition, citizens often have no alternatives but to turn to state institutions for their needs, like acquisition of permits, benefits, licenses, etc. Because of its binding nature and the need to ensure a certain level of guarantees against arbitrariness, the Administrative Act is subject to the principle of legality under control of the judge. Its requirements reflects the process of adopting unilateral administrative acts, which is a combination of both objective and subjective legal aspects. The former includes primarily the premises of legal syllogism, while the latter are related to the final decision and direct application of the law. And I'll start my presentation by objective aspects and legal syllogism in the administrative decision, which started by a law finding by a public algorithm. The translation of administrative law norms into code language is required to interpret the inputs and legally qualify them for the purpose of adjudicating an administrative act. In the context of administrative law, two main approaches to the coding of administrative rules can be distinguished. The first approach is to directly translate the legal norms into the language of a programming code, on the basis of which the rule-based systems that embodies the public algorithm operates. In general, this type of reasoning is closer to individual administrative decisions, which are made based on the applicant's compliance with the requirements listed in the law. This model has a number of drawbacks, the main one being the lack of plasticity of expert systems. However, it's still the most widely used model in administrative law. Moreover, the principle of legal certainty and predictability of decisions is one of the main principles in administrative law, and rule-based AI systems should remain a priority. It is worth noting that the current practice of different countries uses not only the model where an existing normative act is translated into code. A number of countries are currently exploring the possibility of the adoption of legislative and regulatory acts at once in machine-readable form, parallel to the textual form, that is, simultaneous approbation of their program expression. It is supposed that such a model could give public algorithms more legitimacy in their interpretation of the law. The second approach involves the use of machine learning systems that, based on a learning sample, for example, analysis of administrative files with predictable results on them, could themselves make decisions similar to those made by a human agent. Rules formulated by AI itself, based on correlations, could be said to reflect the legal rules, standards, and principles of law applied in making the category of administrative act. In such way, machine learning algorithms could be used as a risk assessment, predictive, and decision support tools. At the same time, decisions made by machine learning algorithms are not transparent and therefore unpredictable and often unexplainable, albeit the fact that the explainability and comprehensibility of algorithmic administrative decisions is one of the fundamental principles of French administrative law, in particular due to the right of concerned citizen to obtain communication of the rules defining the algorithmic processing. On this account, the French Constitutional Council has effectively banned the use of algorithms that can evolve and change their own logic and in administrative decision-making. Next, we'll examine a fact-finding stage and the main issue addressed in the question of where and how the AI algorithms will take input data for their preparation of draft administrative decisions. As there are primarily individual administrative acts, the main inputs are the documents provided by the applicants. In this context, the digital identity of citizens plays here a major role and allows for the acquisition and verification of a considerable amount of data required for decision-making. At the same time, it carries with it a threat to individual rights and freedoms. In France, the first attempt to create a centralized data system called Safari resulted in public censure and its rollback. This is why a new platform, France Connect, is now being established on the basis of the principle of decentralized data storage. Another important source of input data is the data flow between different authorities and even corporations. The missing data could presumably be obtained from scans of documents provided by the applicant, information from which could be extracted by machine learning algorithms that could also verify their authenticity. As far as administrative regulatory acts are concerned, the use and analysis of public big data is promising to determine the optimal regulations in the various areas, such as urbanism, transport systems, the education systems, in particular to inform the administration about a need for a new act. But administrative decision is not just limited by objective requirements, objective aspects, but it has also some subjective aspects, which is concerning the human participation in decision making. The first of them is the aspect of will, and in the civil law system, an administrative act, like any legal act, is an expression of will. That is expressed through the intention to produce a legal effect. In the case of the implementation of AI in the automated adoption of administrative acts, the question arises as to whose will the algorithm express and whether they express it at all, since the AI itself does not possess consciousness and its own will. In the study, the following concept of algorithmic will is presented. Within a legal act, administrative will can be conditionally divided into internal, or the intention to adopt an administrative act, and external, or the volition itself, the explicit expression of the intention. In this case, the source of the intentional will is the state, which has incorporated the intention in the text of the law, and the public administration, which acts in pursuance of this law. The AI algorithm is given the role of expressing the external will, which makes it a kind of an agent that acts according to the will on behalf and in the interest of the administration that implemented it. Therefore, the active participation of the administration in the development of an algorithm is particularly important in order to convey the legal will as precisely as possible in the lines of code. Thus, the process of shaping the administrative will moves from the adoption of the administrative act to the development and adoption of the public algorithm designed to express it. And from the point of view of other subjective aspect of discretion in digital administrative act, the non-discretionary nature of an administrative act is the most common and most sensible of the criteria that determine the admissibility of AI in automated administrative decision-making. Non-discretionary decisions, such as the issuance of certificates and permits, which imply an obligation on the administration to adopt an administrative act if the factual circumstances meet the legal requirements, can be quite successfully fully automated, which would significantly speed up their adoption and relieve civil servants from a routine work. At the same time, discretionary decisions where the decision-making body is authorized to assess the appropriateness of a particular outcome and where several compliant decisions are possible cannot be fully automated due to the uncertainty inherent in them. However, the problem is that the line between discretionary and non-discretionary acts is often not clear. There are only a small number of administrative acts whose adoption is conditional on the existence of unambiguous or numerically expressed facts. A certain amount of discretion can be contained in an ambiguous term, like reasonable periods of case study, or the right to an agent's assessment of legal facts, like integration into French society, to get the French citizenship. The study argues that the totality of administrative acts cannot be binned into discretionary and non-discretionary categories. Rather, it can be argued that there is a certain degree of discretion in the adoption of each individual administrative act, the 0 point of which is a fully bound administrative act that is strictly and unambiguously regulated by law and devoid of any evaluation. A greater degree of discretion implies a greater degree of ambiguity and variability in the legal facts governing the decision, as well as the decision itself. Consequently, the greater the degree of discretion of the act to be taken, the more difficult it is for the AI system to model its adoption, and the less decisive a role in decision-making it can be given. Thus, the concept of the degree of participation of algorithms in administrative decision-making procedure can be represented as ratio of two axes. The higher the discretionary nature of the administrative act, the less significant the role of the algorithm can be in it. Moreover, depending on the degree of discretionality of the act to be taken, the preferred technology of AI changes accordingly from rule-based system to machine learning algorithms used by administrations in the presence of wide discretion as a decision support tool, not binding this administration in any way. Between two examples, countless administrative acts can be identified, as well as combination of different kinds of AI systems optimal for their adoption. At the same time, the participation of a human agent in the adoption of an algorithmic administrative act cannot be completely ruled out. It is a necessary guarantee for its fairness and individualization, as well as respect for citizens' rights. Depending on the degree of algorithmization of the decision, one can imagine many types of such participation, like monitoring automated decisions, considering complaints against them, choosing one option from several offered, finalizing a half-finished administrative act, etc. However, the human agent may be influenced by a machine which he perceives as a source of objective information that defines his decision and whose principles of functioning are incomprehensible. In the context of discretionary acts, such influence can lead to the act being declared unlawful and judicially annulled, as it must be decided independently by a competent person. In order to avoid such a situation, it is recommended to pay more attention to the training of public agents in informatics, up to including the official authorization to work with algorithms. So I thank you for your attention. I will be happy to answer your questions.
Thank you so much, Alexander. I have a first question from Mikhail. Are you going to take into account the case law of administrative courts as constraint on administrative decision making?
In fact, thank you for this question. I'm not very sure now because as for French jurisprudence, the decisions is very rarely motivated. The decisions of French administrative courts because of and so it will be difficult to extract a knowledge and to construct administrative act from an administrative jurisprudence, but some concepts can be extracted from this jurisprudence. I'm not still study this idea, but I will look at it anyway. Thank you.
Thank you. I also have a comment by Monica here. She stated, it's also interesting to see the use of the Article 22 of GDPR used in the case law in Italy. And she states a case law. You may find it in the chat. In the case of automatic decision system applied to the public selection of teachers in the Italian school system of the ministry. Very interesting thesis, she states also. Okay.
Yes, yes. If I can answer the question here, yes, I have studied this article of GDPR and precisely in the context of French law, like French law on personal data, which has been adopted after the adoption of GDPR, which now legalize the individual administrative decisions taken by administrative authorities. But this criteria, like individual administrative decision, is not much correct for a legalization, because there are discretionary administrative individual decisions who can't be now well automated. And for example, we could take another decision of Consiglio di Stato from Italy, where the Consiglio di Stato said that it is much more relevant to automate the decision to repetitive decisions, which cannot concern the discretionary qualification of facts or choose between some opportunities. So in Italy, it is also decided to legalize more the non-discretionary decisions.
Thank you so much. Thank you. I also have another question here. How do
it is the same. So I'm happy. Thank you so much for the answer.
Okay, thank you, Monica. I have another one. How does French law deal with the gray area and the distinction between discretionary and non-discretionary decisions from the administration? If we include AI system to help make administrative decisions, do you think a specific regulation should apply, or should we rely on past, more general solutions?
In fact, thank you for the question. The previous version, not a version of this article, but a project of this article in French personal data protection law has proposed a formulation that the administrative decision can be automated if there is no ambiguity on the qualification of the facts, or there is no ambiguity on the qualification of the law. So in my opinion, it should be very precisely qualified, not to stop the implementation of more sophisticated algorithmic systems, but to make some guarantee of respect of civil rights. And from this purpose, the Constitutional Council of French Constitutional Council has banned the use of machine learning systems. And I think that with more progress in artificial intelligence development, these rules can be revised. Thank you.
Okay, thank you so much. I think we have time for another one. It's very connected to the last one, but I think it has a little bit specification about data transfer between private actors and public actors. You state in your paper that the use of analysis of public big data to determine the optimal regulation in various areas, such as urbanism, transport system, and so on, is promising, in particular to inform the administration about a need for a new act. How to regulate the access by the public administration to these databases? Do you think that the public administration should have access to big data gathered by private actors like Uber, and like in the new events, like the use of geolocalization data to control their compliance with social isolation measures during the pandemics?
Thank you for the question. In fact, I've told much more about public data, so about data which is possessed already by the administration. Like state administration has a lot of data who is delivered by the citizens, by the applicants, by the internal informational exchange. And it was primarily this domain of data, but in perspective, the conclusion of some information exchange between the private actors can be concluded. For example, as I said, for extraction of legal facts, now, for example, to prove your residence, to prove your residence place, your address, you can now use an option to have a confirmation from your electricity contractor that you live in here, and it is automatically going as a proof of your residence. So in future, such a kind of accordance between public and private actors in the domain of data can be enforced, I guess.